2024, an election year like no other. From the candidates to the issues, from voter integrity and analysis, we'll discuss debates, trends, patterns, election laws, and more. This is Vote 2024, Path to the Polls.
Good day. One headline put it this way: the Supreme Court is in the middle of the social media and free speech intersection. It's a wrestling match between the courts and policymakers. At issue is the power of social media and its ability to influence everything from medical decisions to politics, even the outcome of a presidential election. But one of the biggest problems in my mind is the courts, in many of its fights, has become partisan. Welcome to Path to the Polls. I'm Bruce Hamilton, and joining me this morning, constitutional law expert Rod Sullivan from the Newman Group. Thanks again for being here. Appreciate you.
My pleasure.
So, the Supreme Court heard arguments surrounding two cases Monday, and the crux of those cases focused on the federal government's ability to combat what it sees as false, misleading, or even dangerous information online. So let's start with outlining those two cases.
Yeah, well, the two cases that it heard yesterday that it took oral argument on, first started out as Missouri v. Biden, and it's now changed the name to Missouri v. Surgeon General Murphy. But basically what it happened there is that when Joe Biden came in, he created something called the Office of Digital Policy and appointed a guy named Rob Flaherty in charge of that office. And he began sending messages to Facebook about content on Facebook that his office didn't like. And Facebook complied in many cases with monitoring or even deplatforming people. As a matter of fact, 39 people were deplatformed. They don't have any estimate of how many tweets or how many posts were taken down. Some say as many as 1 billion. But they were based upon things that the administration didn't like. Now, we were in the middle of the COVID crisis at that particular time, so a lot of these were COVID related. So, for example, if you questioned whether or not the vaccine had been properly tested, you would be deplatformed, or at least your post would be shadow banned. If you questioned the efficacy of masks, your posts were taken down. Any number of things that surrounded COVID tended to be censored. One of the things that was censored is if you suggested that this was a man-made virus that came from a lab in Wuhan, China, you were off. That wasn't going to be permitted. Then it sort of ventured a little further away from COVID, and it started getting into politics. If you published something that said that Hunter Biden had a laptop and that the laptop had things on it that would be embarrassing to the president, you were gone. You couldn't post anymore. And then it went after satire. There's a group called Babylon Bee, pure satire site, makes fun of a lot of liberal causes. They knocked Babylon Bee off of the platform. So this was the problem that was sort of arising in the course of this White House Digital Policy Office and its interactions with not just Facebook. We're going to talk primarily about Facebook, though. And so what happened was first of all, two states, Missouri and Louisiana, said this is a violation of our citizens' civil rights. So they sued Facebook. And Facebook, with a couple of other social media companies, formed a group called NetChoice. And NetChoice immediately responded to it and said, "Look, we're not going to buckle down. We're going to object to this." Then two other things happened. The state of Florida and the state of Texas passed statutes regulating social media platforms. Florida's was a much more focused approach. Florida said, if you're a candidate for public office in our state, you have a right to have a Facebook page, at least from the day you qualify until the date of the election. And Facebook, you must host this site, and you can't restrict the material that's on that site, except if it's obscene or illegal or something of that nature. And then Texas did something even bigger. Texas said you can't engage in viewpoint discrimination on your pages at all. And if you do, then you can be subject to penalties. And so NetChoice filed suit against Texas, the Texas Attorney General, and the Florida Attorney General, Ashley Moody. And these cases went up to the Supreme Court. So this term of the Supreme Court, we have never seen such a concentration of cases on a single issue since the Civil Rights era. I mean, this is going to be the free speech era of the U.S. Supreme Court. And quite frankly, it's exciting to watch, but it's very difficult to predict what's going to happen.
It's very difficult to predict what happens. And you've got to understand, and we'll be fleshing this out a little bit here because it goes beyond the world of politics. You've got doctors sitting back and they're saying, okay, you look at the COVID crisis, and again, this is something we'll be talking about a little later on, because if the courts rule one way, it could impede us from doing certain types of research. We'll talk more about Florida and Texas as well. So what do courts look at to determine whether and at what point a government crosses the line from voicing its opinion about how a social media platform should treat a specific post to unconstitutionally coercing the censorship and the negative moderation of that post?
Well, to put it in language which I think people will understand, there's a spectrum there. The far end of the spectrum is the Facebook says we're a publisher. We're like a newspaper. We're like a news station. So we get to decide what goes on our station and what doesn't go on our station. On the other opposite side of the spectrum is a dumb pipeline. You're like an internet service provider or a phone provider. You can't discriminate in what goes on your platform. So those are the two extremes. Now Congress stepped into the breach and created a statute called Section 230. And what Section 230 says is you as a social media provider, you are not a publisher. We have established that as a matter of law. You're not a publisher. Well, if you're not a publisher, what are you? Are you a dumb pipeline? And there's become this sort of a middle ground position, which is you're a common carrier, which means you can't discriminate between various viewpoints on your website. Now, what's the basis for making them a common carrier? Well, Section 230 says that you have insulation from liability. All you do is you take somebody else's content and you put it on your page, and you are insulated from personal liability for anything that you put on your page. So we've granted you an exclusive franchise. You can't be sued. And they likened it to the rise of the railroads in the 1880s. You know, the United States government gave railroads eminent domain. You can run a rail line all the way across the United States, and you're going to have the rights to use that railroad. We're giving this to you. But as a result, you can't discriminate. You can't say, I'm going to take your cows to market, but I'm not going to take yours. I'm going to carry your cargo for this number of dollars per ton, but yours is going to cost more. We like you, you can go on our rail line. We don't like you, you can't. So that was the position that's been sort of evolving now. Is Facebook more like a common carrier than it is like a newspaper? And so what the courts have come down on all sides of this question. The 11th Circuit, which Florida is in the 11th Circuit, it sits up in Atlanta, came and said, we don't care what Congress says, you're a publisher. And you as a publisher have First Amendment rights. And as your First Amendment rights, Facebook, you can exclude anything you want. It's up to you. You're the master of your domain. And then Texas came along and said, no, you're not a publisher. You're a dumb pipeline. And therefore, if somebody posts something on your site, which is not obscene and not illegal, you can't moderate the viewpoint in that. So these two cases, these two state statutes came along, and they went immediately to the federal courts. Even before they'd begun enforcement of the statutes, they went immediately to the courts. And the court in Atlanta said, no, we're going to enjoin this statute. And the court that in New Orleans, which governs Texas, said, we're going to let your statute go forward. Supreme Court said, we're going to hold both of your cases off until we can hear them. And that's what happened last week. They heard these cases. They took these two cases together. They gave them 4.5 hours of oral argument, and the justices peppered them with questions. And that's sort of where we stand on those two cases. Now, the two cases that were heard yesterday on the the Missouri versus Biden case was somewhat similar. It went up to the district court level. The district court said, I'm going to issue a preliminary injunction. White House, you can't even talk to the social media platforms anymore. And a number of different, Surgeon General, a number of different administrative agencies. You can't go ahead and make any direction to Facebook on what their content is going to be. And then it went up to the Fifth Circuit Court of Appeals, and the Fifth Circuit said, we're going to uphold that. And then that went to the Supreme Court and got stayed as well. So where are these going to come out? It's a big
question, yeah.
Yeah. Oh, and then we forgot to talk about Volo. Okay, Volo is not even a social media case. The state of New York, Andrew Cuomo, said, we're going to shut down the NRA. And he actually started a hashtag, bankrupt the NRA. And so he went to his division of financial services, a woman named Maria Volo, says, we want you to find a way to use state law to shut down the NRA. And she said, hey, I got it. I got the plan for you. NRA sells to its members insurance for the carry insurance. If you shoot somebody, you have a concealed weapon, and you're sued, well, this insurance will protect you. And so she said, I'm going to go after that carry policy provider, not the NRA. We're going to go against any of the agents, and we're going to go against the insurance companies. And we're going to tell them, if you continue to do business with the NRA, we're going to make your life miserable. And so she did. And she got consent decrees against 3 of these insurers to eventually say, we're never going to issue this carry policy to anybody who's with the NRA. Now, you have to understand, there are competing insurance companies out there. She didn't say, I'm going to go after all of you. She said, I'm going to go after you because you provide the NRA's policy. And then she went to the banks, and she said to the banks, same thing, you do business with the NRA, you host their accounts, you take their deposits and everything, you're going to be in trouble with us. We're going to find ways to make your life miserable. And the third thing is she went to Lloyd's of London. And she went to Lloyd's and says, and this is even the most egregious if it actually occurred, because we don't really have the facts before us, and said, you have a lot of regulatory issues before us, and those could go very well, or they could go very badly.
This isn't a black and white issue, right? Yeah.
Yeah, I mean, it's like, you have a very nice restaurant here. It would be a shame if it burned down. Well, they did the same thing to Lloyd's. They said, we know you're not involved in this, but if you do business with the NRA, you're going to have a very difficult time on these issues you're dealing with. And if you stop doing business with them, things are going to be much easier in your life. They even secured an agreement from one insurance company to never issue a policy to an NRA member anywhere in the United States, not just in the state of New York. So this is coercive behavior. Quite frankly, they'd be more likely to get away with it if Andrew Cuomo didn't tweet so much. Because every time she did one of these things, he tweeted out, we're getting the NRA, hashtag bankrupt the NRA. These are having an effect, they're working. And they posted these things on their website as well. So they weren't being very secretive about it. So the NRA filed a cause of action against Mrs. Volo, the state of New York, essentially. And it went up to the Second Circuit Court of Appeals. And the Second Circuit says, yeah, they have the right to do that. That's fine with us. It's not retaliation. They're not impeding your speech. NRA, you can still say whatever you want, and it's okay. The Supreme Court took virtually no time at all to say, yeah, we're going to review that decision. And that's the decision that was heard yesterday. Now, of the 4 cases that we've talked about, that's the easiest one to make a prediction on. Because if you listen to the oral argument, even the justices who were very disposed to favor social media were sort of saying, hey, look, this goes over the line. This is retaliation. And retaliation using the power of the state government is really not something we're in favor of. And so I would predict that that's going to come out in the NRA's favor. The other 3 cases, boy, is it a toss-up. I mean, you talk about it as being partisan issues. I don't really see it as much as being partisan. It's almost breaking down on gender lines. Because you have 4 female justices, you have 5 male justices. And during the oral argument, the position taken by the female justices was, we were in a crisis. COVID was a national emergency. People were dying. And therefore, if the White House went to Facebook and said, shut down anything that's going to cause people to have hesitancy about taking the vaccine, that's okay. If you're going to shut down any post that says anything about masks being ineffective, social distancing being ineffective, school shutdowns, business shutdowns, if they're going to oppose that, we're okay with the government telling Facebook,
you don't think that the conservative justices played their hand just a little bit in the way they talked about the Biden ruling? Because I think they surprised some people.
Yes. I mean, certainly the court breaks down along conservative and liberal lines.
Yeah.
There are 3 justices who are clearly going to be against the Biden administration in favor of Missouri, and that would be Thomas, Alito, and Gorsuch. And then there are 4 justices who appear to me are going to be very much in the Biden administration's corner, and that would be Jackson, Kagan, Sotomayor, and surprisingly, Amy Coney Barrett, the only Republican female justice. And then there are the 2 that are sort of up in the middle, and that's, believe it or not, Kavanaugh and Roberts. Now you have to understand, Kavanaugh worked in the White House. So this idea of the White House being a bully pulpit to tell the media what to do is something he's very comfortable with.
Yeah, but do you think, I'm getting ahead of myself because this was a question I was going to ask a little bit down the road. Does John Roberts sit there and, talk to the rest of the justices over a cup of coffee and say, look, we've got a landscape here that we've got to navigate, and there's been too much politicking already going on with this court. We've got to navigate this in a different way.
Oh, yeah. Clearly, he wants to preserve the reputation of the court among, more than anything else. And he has the power to jawbone that question among the 9 justices when they sit down. And even more importantly, has the option of deciding who writes the decision. So if he was to go forward and say, okay, and he can vote, of course, because he may be the swing vote. I don't really think on these first 2 cases, on the Biden versus Missouri case, I'm going to make a prediction, but it's a real soft prediction. I think Biden's going to win that case. The Chief Justice Roberts can say, yeah, I'm going to vote with these justices. You're going to have a majority. And Justice Jackson, you're going to write the opinion. And that becomes a very powerful tool because she writes the majority opinion. That becomes the law of the land. Mm-hmm. And on the other side, let's say on the Vullo case, he sides with the NRA. He says, okay, we've got more than 5 votes for the NRA, and Justice Thomas, you're going to write this decision, and you're going to see a very, pro-NRA, anti-New York State overbearing decision coming from Justice Thomas. So that's where Justice Roberts comes as far as the power structure.
All right, let me talk about how we got to where we are today. If social media existed during World War II, during the Kennedy-Nixon years, during the Vietnam era, we would have some of these issues. It didn't. You and I grew up in an era where you had 3 television networks, 3 TV stations. Opinion didn't, infiltrate the news. We didn't know a lot of what was going on behind the scenes. But there are 26 words that are tucked into a 1996 law that overhauled the telecommunications industry, that allowed the social media companies to become the giants that they are today. It's called Section 230. It's essentially what's being challenged. So here are those 26 words. Obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. That put us to what's going before the Supreme Court.
Yeah, this statute was sold to Congress as we're going to prevent obscenity on social media. Because if you look at all of those first words, they're, lewd, lascivious, obscene, so on and so forth. And then we have those last 2 words, otherwise objectionable. And that just threw the barn doors open.
Isn't that kind of vague?
It's absolutely vague. And if you read it in context, it's clear to me that they're talking about they want to keep pornography off of social media. But that's not the way the social media companies look at it. They look at it as, I find Donald Trump otherwise objectionable, therefore I'm going to push Donald Trump off of my platform. I don't like the Babylon Bee making fun of a lot of liberal causes. I don't like their satire.
Can it also be, I don't like the way you think?
Yeah, I don't like you. It can get worse, okay? Mm-hmm. So far it's been, the New York Post, Babylon Bee, Donald Trump, doctors. We forgot about talking about specifically some of the doctors. Doctors who said, ivermectin is another treatment for COVID. You're gone. Hydrochloric, HCQ. You want to take HCQ, you're not going to hear about it on our website. Masks, you question social distancing, you say viruses can't survive outside of the body. I don't care if you're a researcher at Stanford, and which some of these people were. If you're at some of those prestigious universities, if you teach at Harvard, we're going to boot you off.
So some of the things that Latipo's doing.
What's that?
Some of the things that the Surgeon General in Florida is doing.
Yeah. So those words, otherwise objectionable, have been applied to a whole host of other topics. And as I said, it could get worse. I mean, the position that Florida took in its brief, which a very strident position, is, they're imposing Silicon Valley's mores on us. And we don't think that should happen. We don't want social media oligarchs who control the social media landscape to tell us how to think. And it could get worse. You know, they could say, look, if you're a political candidate, you need to believe in these things that we believe in. You need to believe in gay rights, abortion rights, transsexual rights, affirmative action. And if you don't ascribe to these things, you don't get a Facebook page. And the fact is that in today's political environment, Facebook is where a lot of people go first to get their information. So it could really become more oppressive than it is, more restrictive than it is, but it hasn't gotten there yet. But we're sort of on the beginning stages of having that argument of what the social media companies can do. Now, even though Congress, you know, to just give you an illustration of how irrelevant Congress is, Congress passed this section 230, and it said, first of all, social media companies, you're not a publisher, therefore you're not going to be liable for what other people post on your website, on your Facebook page, on your Twitter account, whatever it may be. The first thing that the 11th Circuit Court of Appeals said is, hey, they're a publisher. Yeah, we're going to give them the same rights as we do any newspaper. Miami Herald doesn't want to publish an op-ed in its newspaper, doesn't have to. You don't want to publish an op-ed on Facebook, you don't have to either. Kick it off, boot it off. We don't care, you're a private company. Let some other company come and form another competing social media page that's going to be as influential as Facebook. Well, of course, no other company has ever come forward that competes with Facebook. There's that networking effect. You want to be on the page where your friends are, where the people who, you know, like your posts are going to be. And therefore, nobody else gains traction against Facebook. So they become sort of a virtual monopoly. And according to reports that I see, I know you're not going to believe this, but people said they get more of their news from Facebook.
No, I do believe it.
From television news.
No, I do believe it. And that's frightening because Facebook is invented.
Yeah. So it becomes a very powerful source of information for people, and if it's controlled by, and again, I'm using the words of the Florida Brief, a small group of Silicon Valley oligarchs, then it becomes very lopsided in its views.
And I've got to tell you, with the death of newspapers and the lack of investigative resources and the fact that newspapers are folding left and right, and with news organizations not having the funding to do what they used to do, it's only going to get worse. Mm-hmm. And with people going to resources that are not true news organizations, I worry about the information that's out there that is not vetted. And you know, I hear people repeating things. And remember the game that you played as a kid, Whisper Down the Lane? That information is watered down, and it only gets worse. So what I'm hearing is the core question, especially in Murphy versus Missouri, is whether the government can flag potentially harmful posts to social media companies without it turning into unintentional, to use the word you used before, coercion of speech.
Mm-hmm, mm-hmm. And I really think that the Missouri case is going to get sort of punted. I think what they're going to come down and they're going to say is that none of you 5 plaintiffs or 2 states can show that you actually were you're deplatformed, no question about that. But we don't see the causal connection between the White House sending Facebook an email saying that your posts are misinformation and Facebook kicking you off of the site. And because you can't establish that causal connection, we don't think you have standing. Go goodbye. Thank you very much for your participation. Go home. And I think, I hate to make predictions because you can always get egg on your face, but that's my sort of prediction of what's going to happen with Missouri v. Biden, that it's going to get kicked out. Now the other two is a little tougher. I mean, one of the things that this Communication Act, the Section 230 does say is that we want to preserve political discourse and we want the states to be able to continue to regulate things like social media. So when Florida came and said, you have to give candidates a website, and they called it consumer protection. They didn't call it restriction on speech. They didn't say anything other than, if you're a qualified candidate for a public office, Facebook owes you a website from the date you qualified through the date of the election. That's a pretty narrow instruction, a narrow piece of consumer protection for social media companies and for the public. And I tend to think that might survive. The other things that they said in there is that if you're going to ban somebody or you're going to restrict their post, you need to tell them why. You'd give them a way to appeal. All those things are fairly reasonable. The Texas statute said you won't engage in viewpoint discrimination. That's a much broader prohibition, and that might be too broad, and it may not survive.
Let me get to the health implications. So right now, people are being asked to go ahead and get COVID shots because COVID is, again, becoming a problem, and people are skeptical because you know what happened during the pandemic. And during the pandemic, the CDC and government might email directly with somebody at Facebook, especially if it wanted to set up a hub for information. And similar scenarios came for voter misinformation, election integrity, all kinds of public emergency. So that question comes into play there as well.
It does, yeah. And the thing is that I think in hindsight, there are a lot of people who are beginning to say that the naysayers, the ones who were questioning the vaccine efficacy, are sort of being proved, right. The very first word about the vaccine was, you get the vaccine, you won't get COVID. And then people started getting the vaccine and started getting COVID. Oh, well, you need to get the booster. You get the booster and the vaccine, then you won't get COVID. And people got the booster and the second booster, and they still got COVID. And so they said, well, COVID won't be as bad if you have the vaccine and the booster. And we don't know if that's true or not. And then the same thing with masking. You look at those countries that didn't engage in masking and didn't engage in social distancing, like Sweden had better outcomes than the United States. So maybe those people, those doctors from Stanford that said that masking made no difference and that shutting down schools made no difference, maybe they were right. And so as a result of what happened during the COVID crisis, there's a great distrust now for information coming out of the Surgeon General's office and the CDC, and information being blocked by social media that they were not right. And then there's the other question is, was the vaccine properly tested? Does it have any side effects? Are people experiencing higher rates of myocarditis who have had the vaccine than didn't have the vaccine? So maybe hesitancy on the vaccine wasn't necessarily a bad thing. So yeah, that's all back on the table now. The question is Facebook going to go again restrict all those posts, or is it going to allow a free debate on whether or not you should take ivermectin, HCQ, alternative treatments, whether you ought to take the vaccine or not take the vaccine?
Just sit back and go, oh, it's like the flu.
Yeah, well,
and we're not playing doctor here. I'm just talking about people who react. All right, let's talk about what played out in the courts yesterday. The High Court seemed kind of skeptical about the arguments it heard to remove online misinformation from social media sites. And it was interesting to note that the conservative justices basically sided with the liberal wing on the issue of the Biden administration and accusations of a sweeping censorship campaign. Did that surprise you?
It did, yeah. As a matter of fact, a lot that happened at the argument yesterday surprised me. First of all, Justice Kavanaugh being sort of on the side of the White House surprised me, but then somebody else explained, well, he was in the White House in the Bush administration, so maybe he's saying, hey, these are things that I did. I didn't have social media, but these are things that I did. I would call up reporters and tell them, you should kill that story. That's misinformation or whatever. And so he seemed to side with them. Kagan was in the Clinton White House. She was clearly on the White House's side in this case. And there really wasn't much vigorous debate in favor of the plaintiffs. And I mean, Justice Kagan at one time even says something to the effect of, I can't believe the factual representations that you've made in your brief because they're not supported by the record. And that might not sound like much of an admonition to a non-lawyer, but if you're a lawyer and you hear somebody say that, basically she's saying, I think you're a liar. And that's bad. If the Supreme Court's telling you they don't believe you, they don't trust you, boy, that's really bad for you. And Justice Jackson was, sort of not as strident as Justice Kagan. And Justice Barrett was coming along with some of the same sort of scenarios. Well, what if? What if there was a post on social media counseling teenagers to jump out of a window, and teenagers started doing this? Facebook would be able to go ahead and take those posts down, wouldn't it? And the counsel of the plaintiffs had said, yeah, well, there's a compelling interest in doing that, and therefore they could. But there was no compelling interest with regard to our clients. But that argument was not getting a lot of traction. It was embarrassing, quite frankly. I mean, I've argued before the Supreme Court, so I know what it's like to be embarrassed a little bit, but not a lot. And those people were embarrassed a lot. At least the one attorney in particular was embarrassed a lot. I felt badly for him.
So look, nobody's going to argue there is misinformation, there's disinformation on social media, but I think the question is how far does the court go in regulating things and at what cost to our freedoms?
Yeah. The question is, this is how far can a social media company go to censor things based upon the viewpoint they express? I think most people feel like when they put something out as a post on Facebook, it's going to their friends. I mean, it's accessible by everybody, but it's going to those people who have friended them or they have friended on Facebook. And that it's like a conversation in a big group, that you should be able to say pretty much whatever you want to say as long as it's not obscene or illegal. But Facebook's position has been, no, we can go ahead and we can restrict what you say on the Facebook page, and we're going to do that. Or we can post a message that say this is misinformation. Or we can put a covering over it and saying, do you really want to see this video? This is violent content. And I think, where are we going to come down on this? First of all, I don't see the court as providing an answer to these questions. I think it's going to have to come from regulation, but as we mentioned, Congress is fairly dysfunctional.
There's no arguing that.
Yeah, we didn't mention that today, but I mean, you and I have discussed this in the past. Congress is fairly dysfunctional. Doesn't pass any bills, doesn't pass a budget.
That's because there's personal agendas at play. I mean,
there's personal agendas. There are procedural things in place which keep anything from being done. And so the question is, can the states therefore regulate this? Now, Facebook threatened to pull out of Texas. They said, look, if you're not going to allow us to do any viewpoint discrimination, we're just going to say, if you're in Texas, you can't use our site. Is that really going to happen? Boy, that would be an awful big hit financially to that. And then one of the justices pointed out, this is what the European Union already does. And I didn't know this, but the European Union apparently says you can't discriminate on the basis of viewpoint. So why would you pull out of Texas if Europe already has this regulation in place and you didn't pull out of Europe? And I think they backpedaled a little bit and sort of like, well, I'm just a lawyer. I don't know what Mr. Zuckerberg is going to do. Yeah, maybe it's a little bluster. But I think that might be the only route, though, is for the states, particularly a consortium of states. Instead of states just acting individually, if a group of states got together and said, similar to Florida's law, you can't discriminate against political candidates on the Facebook page. If somebody is qualified to run for office and they want a Facebook page, it's like, could you imagine the telephone company telling somebody, you're a candidate for public office, but we're not going to put phones in your campaign headquarters because we don't like your positions. We're not
going to let you communicate.
Yeah, we're not going to let you communicate. Well, Facebook has become more important than the phone in communicating with a large group of people these days, and in the electoral process. And I could see states coming together and saying, look, we think this is a general policy. We want to preserve political debate. And therefore, if somebody is a legitimate candidate for political office, you, Facebook, are not allowed to discriminate against their viewpoint. And not only can you, deplatforming is, of course, the most egregious form of restricting speech, but they order posts on Facebook based upon what they think, you'd like. And therefore, they can shadow ban you, or they can push you further down in the feed and things like that. And the Florida statute dealt with all of those situations and said you just can't do that. And if you do it, you got to disclose it. And I don't think they wanted to disclose it either. The other thing that the states can do is they can say you've got to come up with uniform guidelines that apply, that so somebody knows what they could do or what conduct would result in them getting shadow banned or kicked off your site. And you've got to apply these actions uniformly. And that was in both the Florida statute and the Texas statute. So there's a little bit of agreement that social media platforms ought to do that. The other thing that the state of Florida did is they said, if there's a violation of this, the Division of Elections is empowered to investigate it. Well, Facebook hated that. Matter of fact, not only did they sue Ashley Moody, the Attorney General, they sued every single member of the Florida Elections Commission. Why they had to join them all, I don't know. I would have thought one would have been adequate. But anyway, and then they said, the Division of Elections, if you find there's been a violation, you can issue a fine up to $100,000. Well, of course, to Facebook, $100,000. I mean, that just passed in the last 2 seconds we've been sitting here. But nobody wants to be fined by a state government.
Yeah.
So maybe the legislature, someplace, either Congress, if it gets its act together, or the states, probably they will provide the answer as to where this line is between a publisher and a dumb pipe. Where does it come to the point where the viewpoint discrimination violates the rights of citizens?
I mean, given all this, they banned Donald Trump from Twitter. Was Twitter in its bounds to do that?
I would think that they would say no, that Twitter being a candidate or being the president of the United States, he probably was entitled to utilize social media.
Yeah.
And so those are the things that got him in trouble.
Yeah.
It was Twitter banning Donald Trump, banning the New York Post. The New York Post was founded by Alexander Hamilton. It's been around for a long time. Now, of course, it's changed over the years. Banning Babylon Bee, and then banning these Stanford, Yale, and Harvard doctors who were questioning the vaccine information. All of these things are what really have gotten them in trouble.
Yeah. This is what we've got to be mindful of. How the justices settle the fight could have a profound impact on the upcoming presidential election, public health, national security, and the degree of freedom that we have to express ourselves.
Mm-hmm. Yeah, and clearly it's going to have an effect on that. The one thing I do see is in the Texas and Florida cases, the justices are being very cautious. These challenges that NetChoice brought are called facial challenges. They said under no circumstances can these statutes take effect because they facially violate the U.S. Constitution, the First Amendment. We don't have a case. We don't have a situation where it's been applied. We're just going to give you the statute and say, is this constitutional to do this? I think the Supreme Court may say, it's too early to decide that. Let's send it back to the states. Let's let the states start applying the statute and then come back to us after they have applied it in some fashion which you think violates your First Amendment rights, and then we'll decide it. So as far as this upcoming election, I don't think we're going to have any kind of settlement of the social media issue. How is it going to affect our right to express ourselves? Well, I think this has been a little bit of a shot across the bow of Facebook. I think Facebook's going to be a lot more cautious about whose posts it bans from now on. Rob Flaherty, the director of social media for the White House, is gone. And so consequently, the White House is probably going to be a lot more cautious about what it suggests ought to be taken off Facebook. And the thing is, the COVID crisis is over. And the COVID crisis is what precipitated a lot of these initial contacts anyway between Facebook and the White House social media office, digital content office. And they became bolder and bolder as they got more and more things banned off of Facebook. And I think maybe they got a shot across the bow as well. And they may be saying, we better not do this. Look what's happening to Jen Psaki. Her far prior press conferences are being excerpted and posted and saying, this is what Jen Psaki said, and this is what actually happened, and she was wrong. Nobody wants to be the next person who that happens to.
Right. I know you said earlier it's not something you want to do in the way of predictions. Court is expected to make its decisions come June.
Okay.
Where does this land? Does the court, walk softly and carry a big stick?
Let's talk about the cases individually. On the New York case, I think NRA wins, the state of New York loses, goes back there for further proceedings. On the Texas and Florida cases, I think the court decides too soon. We don't have an actual situation in front of us, and therefore we're going to go ahead and turn it back to the states. We're going to set aside the injunctions and let the states start using these policies. And then with regards to Missouri versus Biden, I think they're going to say none of you out there who came to this court can show us how you were actually banned because of what the White House did. Therefore, there's no case, dismissed, lack of standing, go back home. And then maybe some other case will come forward where somebody will say, okay, I can prove that I was shadow banned or that I was deplatformed because of something I said, and the White House objected to it, and then we'll have another case.
And that goes back to where you said the attorneys kind of had some egg on their face and were a bit embarrassed.
Yeah, they did. And, I didn't foresee that coming because they had such slam dunk decisions in the Northern District of Louisiana, and the Fifth Circuit were squarely on their side. And then they go to Washington, D.C. And this is actually a comment that some of the commentators have made. You were in the swamp when you were in D.C. in front of the Supreme Court. All of those Supreme Court justices have worked in the federal government in Washington, D.C., and therefore there was not a good audience to be in front of criticizing what the White House did. So, yeah, I think that they'll punt those questions back. They'll be very cautious in deciding these questions. But this issue is going to be around for a while. It's like the civil rights issue. Brown versus Board of Education didn't end civil rights cases. I mean, we had a decade of cases involving school busing and things of that nature. I think we're going to have a decade of First Amendment cases.
So in these days in which this Supreme Court has been maligned on a variety of issues, in this case, its integrity should be intact?
I would say yes, and it's proceeding cautiously. I would say that's where I would honor the court by saying they're not going to jump into this issue and decide it right away. They're going to really wait until they've had a chance to digest a real case, and then they're going to decide.
Rod Sullivan, you always give us some things to talk about. Appreciate you.
My pleasure. Thank you, Bruce.
All right, and we'll be back. Actually, Rod will be back on April the 9th, I believe it is. We're going to talk about DEI. The Supreme Court made a ruling on DEI, and while that ruling didn't have a direct impact on business, it has had a profound impact on business. It's had a profound impact on the way universities do business and the way many companies do business. So we'll look forward to that chat. So if you want to watch this program again on demand, share it with some folks. You can do so on the News4JAX YouTube channel, on News4JAX Plus, and News4JAX.com. I appreciate your time. If you want to weigh in, you can always email me at bhamilton at, I almost gave you my personal email, bhamilton at wjxt.com. I appreciate your time. Have a great day.
See why every day more people are choosing News4JAX, Northeast Florida and South Georgia's #1 source for local news.